Welcome to No Opinion, everybody. My name is Terrell Hussein, and this is a very busy day. I had 3 documents coming at me today, and 2 of them were in reference to the January 6th case. The one that we're about to cover right now is the government's response to Trump's team response to Jack Smith's DOJ team request for protection. So I'm just going to jump right into it. This is No Opinion. Thank you for joining me as I read this. I really do appreciate it because I feel like a fool reading this by myself. But here we go. In the United States District Court for the District of Columbia, United States of America versus Donald J. Trump, government's reply in support of motion for protective order. The central purpose of criminal discovery is to provide the defendant with materials necessary to prepare for a fair trial, to facilitate the efficient production of discovery to the defense. The government's proposed a reasonable protective order consistent with current practice in this district. The defendant instead proposed an order designed to allow him to try this case in the media rather than in the courtroom. The safeguard witness privacy and integrity of those proceedings, the court should enter the government's proposed protective order. Background: the government filed this motion for protective order Friday, August 4th, 2023, ECF number 10. On Saturday, August 5th, the court entered a minute order requiring the defendant to file a response to the government's motion by 5 p.m. Monday, 7 p.m. On Sunday, August 6th, defense counsel appeared on 5 television programs to discuss this case in detail, publicly commenting on topics including the parties' disagreement over the protective order, the defense's planned legal arguments, the defendant's actions and statements during the charged conspiracies, and expected testimony of prospective witnesses. For instance, regarding the protective order, the defense counsel stated on CNN, this protective order that's being suggested by the Biden administration is an effort to keep from the press important non-sensitive information. And we will not agree to keeping information that is not sensitive from the press. The press and the American people in a campaign season have a right to know what the evidence is in this case, provided that this evidence is not protected otherwise. So we're going to oppose it as we have. But for whatever reason, these lawyers on the prosecution team want to keep that from the press. Defense counsel then suggests that the government, by its proposed protective order, was trying to impinge on the freedom of the press. Bullet 2. On ABC, this is an attack on you and members of the press. I'm really surprised people haven't spoken out about it. What the Biden administration is trying to do is prevent the press from learning about exculpatory and helpful information, evidence that the people have a right to know about. What the position of the prosecutor is in non-sensitive ordinary evidence should not be disclosed to the press. That's shocking. Not only do they want to violate President Trump's First Amendment rights, they want to violate freedom of the press. And I'm surprised that the major networks aren't filing papers along with me on Monday. Defense counsel then suggests he could get the ABC reporter a lawyer to engage in litigation over the protective order. On NBC, well, I'm shocked. I can find you a lawyer to address this, but I'm shocked that all of the news media outlets aren't protesting what the government is trying to do. They're trying to say that we have discovery that's not sensitive, but we don't want the press to hear about it. And Mr. Trump, our team is saying, President Trump is saying that if there's evidence out there that the government has the exculpatory or informative, then the press has the right to know. But the Biden administration doesn't want the press to know that. And I'm shocked that there aren't petitions now filed in the district court opposing what the Biden administration is doing. On CBS, we're all in favor of protecting sensitive and highly sensitive information, but it's unprecedented to have all information hidden in a criminal case, including, by the way, information that might be exculpatory and might be exonerative of President Trump. The Biden administration wants to keep that information from the American people. On Fox, the Biden administration wants the judge to put in place an order that will prevent the press from obtaining exculpatory and material information that might be relevant to these proceedings, even though President Trump has argued from the very beginning that this is an attack, this indictment is an attack on his First Amendment rights. Now, what the Biden administration wants to do is deny all Americans the opportunity to learn non-sensitive information about what the case involves in a political season. Defense counsel continued, "I'm convinced the Biden administration does not want the American people to see the truth, and they acted on it by filing this protective order, which is an effort to keep important information about this case from the press. I'm shocked that all the networks haven't lined up and filed pleadings already objecting to this very broad attempt by the Biden administration to keep information away from the American people during the election season. The American people have a right to know. Of course, Joe Biden doesn't want that to happen." In television appearances, defense counsel also made specific claims about the defendants allegedly said and did during the charged criminal conspiracies, and discussed anticipated testimony of Michael R. Pence, stating on ABC that the former vice president would be one of our best witnesses, and on CBS that the vice president will be our best witness. On Sunday afternoon, the parties conferred twice by phone. Defense counsel also shared a red line of the government's proposed protective order. With the parties unable to reach an agreement on the proposed protective order, the defendant filed his proposed protective order Monday, August 7th. See ECF number 14. Argument. The defendant's proposed order would lead to the public dissemination of discovery material. Indeed, that is the defendant's stated goal. The defendant seeks to use discovery material to litigate this case in the media, but that is contrary to the purpose of criminal discovery, which is to afford defendants the ability to prepare for and mount a defense in court, not wage a media campaign. The court should instead enter the government's proposed order. The government's proposed protective order, applicable to all discovery produced by the government, is consistent with others routinely entered in criminal cases in this district. See United States v. Price, ECF number 13, United States v. Farrell, 122, Protective Order Governing Discovery, United States v. Bannon, 670, and ECF number 20, Protective Order Governing Discovery and Authorizing Disclosure of Grand Jury Testimony, United States v. Edwards, ECF number 14, Protective Order Governing Discovery. The defendant's principal objection to it, as defense counsel stated publicly yesterday and in conference with government counsel, is that it would not permit the defendant or his counsel to publicly disseminate or publicize in the media various materials obtained from the government in discovery. But there is no right to publicly release discovery material because the discovery process is designated to ensure a fair process before the court, not to provide the defendant an opportunity to improperly press his case in the court of public opinion. See United States v. Cordova, A trial court can and should, where appropriate, place a defendant and his counsel under enforceable orders against unwarranted disclosure of materials which they may be entitled to inspect. Quoting Alderman versus United States. Seattle Times versus Reinhardt, 1984, noting that discovery rules are a matter of legislative grace and litigants have no inherent right to disseminate what they obtain through the discovery process. The defense counsel's stated goal to publicly disseminate and discuss discovery material in the public sphere is contrary to the general principle against pretrial publicity and inconsistent with the district's local rule regarding the conduct of attorneys in criminal cases, and the court should not enter a protective order that permits such harmful extrajudicial publicity. As an initial matter, the court can and should exercise its discretion with respect to the protective order to prevent dissemination of discovery material that could prejudice the jury. Accord Gannick CO versus D. Pascal, 1979. A trial judge has an affirmative constitutional duty to minimize the effects of prejudicial pretrial publicity. United States v. Brown, circa 2000. Other principal dangers of pretrial publicity include disseminating to the press inadmissible evidence, the exclusion of which at trial is rendered meaningless when news media makes it available to the public, as well as creating a carnival atmosphere which threatens the integrity of the proceeding. Quoting Shepard v. Maxwell, 1966. This district rules prohibit defense counsel from doing precisely what he has stated he intends to do with discovery. If permitted, publicize outside the court details of this case, including the testimony of anticipated witnesses. Local Criminal Rule 57.7 provides that it is the duty of the attorney in criminal cases not to publicly disseminate information or opinion regarding, among other things, the existence or content of any statements given by the accused, or the identity, testimony, and credibility of prospective witnesses. This is because such statements risk tainting the jury pool with inadmissible evidence or otherwise harming the integrity of these proceedings. See Gentile v. State Bar, Nevada, 1991. Because lawyers have special access to information through discovery and clients communicate their extrajudicial statements, pose a threat to the fairness of a pending proceeding, since lawyers' statements are likely to be received as especially authoritative. The court should not grant a protective order that would allow defense counsel or defendants to disseminate evidence such as snippets of witnesses' interview recordings, no matter how short, misleading, or unlikely to be admissible at trial under the federal rules of evidence, and claim that it supports some position the defendants later may make in pretrial motions or at trial. Such conduct has the potential to unnecessarily inflame public opinion, short of all relevant facts, intimidate witnesses, pollute the jury pool, and in general degrade the integrity of the proceedings in this court. See Bridges v. California, 1941. Legal trials are not like elections to be won through the use of the meeting hall, the radio, and the newspaper. The goal of the defendant's proposed protective order, prejudicially publicity, is antithetical to the interest of justice. In addition to the general principle, the court should enter protective orders that prevent public dissemination of discovery in this matter. The government below sets forth certain other specific deficiencies in the defendant's proposed protective order. Paragraph 1. The defendant proposes replacing, unrelated to the discovery process, with other than government production. The problem with this change is that it would allow defense to obtain through trial subpoenas sensitive information learned through discovery and under the defense proposal, publicize those materials. The government's proposal would prevent such a potential end run and should be adopted. In paragraph 2, the defendant proposes including other attorneys assisting counsel of record. Without a clearly defined relationship of employment or privilege, this language is boundless. For example, several co-conspirators are identified as attorneys, whom the defense might interpret as other attorneys assisting counsel of record. The court should not accept this edit. In paragraph 3, and relatedly in paragraph 9, the defendant proposes replacing the language regarding the persons employed to assist in the defense with persons assisting in the defense defined as including any attorneys, investigators, paralegals, support staff, consultants, or expert witnesses who are advising or assisting defense counsel. In a meet and confer call, defense counsel stated their intention is that this language should not be read as broadly as its plain wording, and indicated a willingness to work on language to that effect. The defendant proposed language is boundless and would allow virtually any volunteer to access discovery, as well as any co-conspirator or fact witness. The government's language is more definitive, or more definite. In paragraph 8, the defendant proposes removing the defendant's definition of sensitive materials, recording transcripts and interview reports, and related exhibits of witnesses' interviews. In a meet and confer conference, the government clarified to defense counsel that the government intended to produce in discovery transcripts and audio recordings of witness interviews conducted outside of the grand jury process. The defendant thereafter maintained his proposed edit, an edit that would allow the defendant to release to the public these recordings, transcripts, and interview reports. The defendant's position here makes clear the defendant's intention to try this case outside of the courtroom. The court should reject the defendant's proposed modification. The defendant proposed deleting paragraph 8F. This would have an effect of removing from the order's protection broad swaths of unredacted witness interviews and other materials obtained from the governmental agencies, including the House Select Committee. For the same reasons that it would be inappropriate to allow defense counsel to publicly disseminate transcripts of witness interviews conducted by the government, it also would be inappropriate to permit dissemination of witness interviews conducted by other government entities. At the end of paragraph 8, the defendant proposes that the government conspicuously mark all sensitive materials, presumably on each page of each such document. The defendant's proposal is logistically unworkable and would serve to delay the government's production of discovery. Instead, the government's proposal contemplates clearly defining sensitive material in the cover letter and or source logs accompanying the discovery production, thereby eliminating needless delays and getting defendant the discovery he claims he wants. In paragraph 10, the defendant seeks to prohibit his counsel from confirming that his notes do not contain personally identifying information such as Federal Rule of Criminal Procedure 49.1. But this condition, which is included in the protective order on which the defense claims to model its proposal, is particularly important here because of the defendant and his co-conspirators' practice as described in the indictment of publicly targeting individuals. See example ECF number 1, indictment at 26, 32, 42, 44. The defendant's edits to paragraph 11 through 13 are inappropriate. The new paragraph 11 is a direct contravention of local criminal law, criminal rule 49F6. The additional edits to the new paragraph 12 and 13 unnecessarily complicate what the government proposal makes straightforward. Should trial procedures later necessitate any modification of the protective order, such modification is expressly contemplated by paragraph 13 of the government's proposed order. The court should accept the government's proposal. The government conclusion. The government has proposed a standard reasonable order that will streamline the flow of discovery to the defendant while preserving the integrity of these proceedings. The defendant has proposed an unreasonable order to facilitate his plan to litigate this case in the media, to the detriment of litigating this case in the courtroom. Normal order should prevail. No oral argument is necessary. The court should enter the government's proposed protective order. Respectively submitted, Jack Smith, Special Counsel. There it is. That is the response. And again, very well written. He addressed all of the concerns, and even that were raised by the Trump team in their opposition. So the next step is going to be what happens tomorrow in court, and they're going to make a ruling. And I'll be here and I'll read that ruling to you all, because this stuff that is written in these documents, this is the actual scoreboard. This is how the game is won. This is where the game is actually played. Not listening to these random people talking about what they think they're going to do here, what they think. This is where the meat is. And if you like this kind of content, if you like what I'm doing, please like and subscribe, because I'm going to keep doing it and I'm going to keep getting better at it. And with your feedback, I'll even get even better. So, please like and subscribe, because I'm going to be here because this stuff is interesting and it's very fascinating to me. This is No Opinion, and my name is Terrell Hussein. Thank you for watching.